todos e
Good
todas.
morning to all of you.
Sou Manuela Carneiro Roland.
I'm Manuela Carneiro Roland.
Professora da Faculdade de Direito e
I'm a
Direito
professor
Federal
in the Law School of the Federal University of Juiz de Fora, General Coordinator of OMA, Center of Human Rights in Companies, and now at 9 a.m. we are starting the 8th edition of our international seminar on human resources in human rights in companies. I'm sorry. I'd like to remind you all that we have simultaneous translation for Spanish and English. So in this globe on the bottom bar, those who are going to speak should choose your language of preference, and those who are going to receive interpretation, you are going to do it as well. So we are going to ask our participants and the speakers to speak slowly so we can make it easier for the interpreters to translate. I want to thank you and our acknowledgements before starting the event. I want to thank Gonçalo Berron and Professor Adoracion Guanan. As they speak, I'm going to introduce them further, give you a little bit of background about them. But first, I want to thank the Federal University of Juiz de Fora, the pro-rectorship of graduate students, our rector, Lívia Coimbra, the law school of the Federal School of Juiz de Fora, where I am the principal, and Dr. Aline Araújo, the Ford Foundation that has been supporting us from the beginning, Friedrich Ebert Foundation. Also, I want to thank the Observatory of Consultation and Free and Informed Consent was supporting us in this 8th edition of this event. HOMA, as many of you may know, since 2012 has been working within the law school of Federal University of Juiz de Fora. The name of our institution already expresses our main goal, which is, in addition to better identify this field of research and action that we call human rights in companies, that is internationally recognized as the business and human rights. I think that we would like to put human rights in the center of the entrepreneurship, of the model, of the thinking, of the development model, until the full consolidation of this concept in territories, understanding the relationship between all stakeholders, the enterprises, the state, the communities around them, all the stakeholders in the territory. So we have, I'm sorry, she is muted. We cannot hear her.
Desculpe. Eu não sei se até onde vocês me ouviram.
I don't know if you heard me, but we were. So it's important for us to understand this idea of the impact on the territory, the way in which we have the different impact, the different relationships between the enterprises, the state, the different stakeholders, the people that are affected by the impacted by the enterprise. When we talk about the state, we talking about the legislative branch, the judiciary branch, the different agencies that will have an impact on human rights, also international initiatives that determine the protocols and the way in which, so the analysis of national action plans, we have a human research on that. We have new initiatives. We have existing movements, but there's a regional demand from Europe for leadership in this area. And we have the process of negotiation on the international treaty on businesses and human rights. So this is based on the diagnosis of a corporate impunity. So we are living in, and this is the feeling, the phenomenon that prevails on the global south and also in some regions of the global north, is that companies are benefited from the corporate impunity, benefiting especially transnational companies. This is a phenomenon that should be fought against, and we try to contribute to potentialize the struggle of those who are impacted by violations of human rights, fighting against corporate impunity. And we need so actions carried out as in networks. So we are going to see our global campaigns, the Alliance for the Treaty on Businesses and Human Rights. We have the Rio Doce Research Network that focus specifically in the dam bursts of Fundão and in Brumadinho. We have the Rio Doce Observatory. So we have different research centers, different civil society organizations that will be here with us. So I want to thank all of those who are here, who will be able to participate in this workshop. And this year, in fact, we're going to have two workshops, one more focused on popular advocacy and other on the perspective of Convention 169 of the ILO. So you will have the contribution of specialists in the area. So without further ado, I pass the floor to our colleague and friend, Gonçalo Berrón, who's represented the Global Campaign and Friedrich Ebert Foundation, a long-term partner in this struggle. Good morning, everyone. Good morning, all of you. Good morning, Adoración. Good morning, Manuela and the participants. I want to thank on behalf of myself and also on behalf of Friedrich Ebert Foundation the opportunity to share this moment with you. So I was thinking that we have been partners for a long time. I think since the second event, or maybe the first one even. So for me, it's extremely interesting to be here as an institutional partner, but also a political ally. Be it in the from the international seminar that we here in this last 8 year, and the evolution of this debate, the strategic partnership that we have developed with Roma, and in the fight for this struggle, both institutionally as Friedrich Ebert Foundation, as an activist, we have been benefiting from Oma's work. It's a struggle that has evolved a long time, reaching high levels of development and complexity. And I would say that there are not projects of this depth around the world. There are not many projects of this depth around the world. So I want to congratulate and thank Professor Manuela Carneiro, Roland, and all the team. And also to highlight this point that for me was one of the virtues that Professor Manuela Roland, because she has always been open and she has always showed this vocation to include and to train people. So along these years, many have worked with Homa, and I see a number of young people in this very complex space of action. And for these young people that are starting in the political struggle, in the research on human rights, it was an extraordinary opportunity. So as Friedrich Ebert Foundation, we recognize that, we acknowledge that, and I want to thank you. I admire your work, Professor Roland. So this is topic where you have extraordinary knowledge. This debate on businesses and human rights, I'm not going to um, start from the beginning because you know this history, but this the recent history as of 2013, it's when a number of countries, as we know, decided to state publicly in the multilateral environment that our principles of human rights were not enough. And this coincided when a number of different stakeholders have already decided to create a campaign to defend human rights. So the first part of this debate was to build this feeling that there was a consensus that had been adopted, that the guide, so this first statement was that the guiding principles were not enough, but this had already been challenged. So we wanted to build more on this feeling that the fact that we needed to do something, that this fact that there was nothing left to do was not true. So this was like as if we were challenging the common sense. The common sense, oh, the price guiding principles were a major step ahead. They took us a lot of effort. There was a result of consensus. So it's this issue of businesses and human rights is solved. There's no problem there. So we had to challenge that. That was our initial task. And building up on that, it's amazing how the world works with this idea of common sense. And it is as if things are already solved, and everyone else that is challenging that, they are all crazy people. They don't know how things work. So it is as if it was collectively misleading. Of course, that this is a manipulated idea from my point of view. So everybody starts to repeat the same thing, and oh, this is an universal truth. I remember that I learned in my epistemology classes that the best way to mislead someone is when everybody says the same thing in a group. It is as if this thing was a truth. So the major union federations, the major agencies were saying that, well, the guiding principles are there, so it's all solved. But no, we have to overcome this idea. We have to, so this is our first political task, to defend the process itself. And this step has been taken, and you have cooperated very strongly to this mission of demystifying this common sense of something that was not actually true. So we have consolidated this process, this struggle, along this first 3 sessions of the working group. And when we started the negotiation, we saw that we were on the right path. So we resisted to different parties that challenged that our intention, that they were stubborn on the fact that this was not a necessary initiative. And now, with this, with our drafts of our work, we started on a new form of negotiation. So to me, the best snapshot was Gonçalo Berron sitting, looking at the work of our advocates, our activists working strongly in the production of different languages, different explanations, different contributions, which were theoretical in the courts of law in our last session of our board. And I'm a person more that works on the political side. So it was reduced to, it was all reduced to making sure that there was this space for debate and trying to avoid different boycotts or trying to bombarding uh, to destroying the process of the treaty from the inside. So what I want to say is that the task and the challenge that we all have is a technical one. But so this is a translation of our political willingness. And in that, you at Roma, Adoración, contributing from her academic seat that she has, you combine the knowledge of law with the practice. We say that there is Adriana Masso here, which is leading the legal discussion on Brumadinho. So this is the contribution that is essential to this step that we are facing now. So there's a lot of debate here to be carried out, and we must find the balance between technical discussion, activism, political mobilization in order to get a treaty that is good for us. Of course, there's a lot of challenges to be faced, but we cannot lose the faith, lose the willingness to build on that. So this work that we are doing here, this kind of debate is essential because we are challenging the doctrine of human rights, not because it's something out of our desire, but because the world needs it. If the doctrine of human rights stays as it is, we are going to have a problem, as we are already having. So we are on the border, on the frontiers of the debate on human rights. This is a difficult place to be. It's a difficult border to go beyond. It's been more than 50 years at least that we have been working with this framework, with this doctrine. And the world has changed, but the doctrine has not. So we must understand that we have to deal with that, and we have deal with that with different capacities, different qualification in a qualified space, and we must go beyond. Otherwise, we are not going to solve the problems caused by globalization. So finally, I want to say that this is an effort that must be carried out at a national level as well. In this sense, I want to thank and congratulate the work that has been done in Brazil by Roma. I have always said, and we are going to discuss that on Friday, that the problem is not only an international problem, the problem is in each one of our countries at the level of the national states, because we have national plans as well. We have our recipes to solve the problem, but they do not necessarily solve them. So this process that we have been carrying out together with different parliaments to build what we call legal framework is an advance. It's an advancement. More specifically, this is present moment, which what is being discussed here is due diligence. It's not that we are against due diligence. We are against something that has been put there. It is as if we were saying, "Oh, this has already been done," and everybody agrees with due diligence. But due diligence for, forces the company to foresee the way in which they are going to behave. But that's it. And why do we find for justice, for fair treatment for those who have been impacted by the businesses? So, and what happens if a company that has a due diligence in place violates human rights? So, I have no question that this is what exactly what we are defending: the possibility to think beyond, to think beyond due diligence. So in this sense, a homeless contribution and spaces such as this one, where we can share our experiences and get more nationally enriched in this struggle, is essential to all of us. So I thank you for the opportunity. I thank you for the partnership. And I wish you all the luck in this 8th International Seminar. Thank you.
Thank you, Gonzalo. I always say that OMA has the merit because of the relationship that we have with civil society and social movements and the networks that allowed us to be close, to have this trust. So that's why OMA is responding to an important agenda for society. So we have to thank you, because we were able actually to develop all this potential thanks to this openness and the trust that was deposited in us by the networks, by the global campaign in you. So we are the ones who have to thank you. So now I'll turn over to my friend Professor Adoracion Guaman, who's going to talk about the academic perspective, which is the background for the beginning of the seminar that we built on for the main issues that we're going to be presented to during the seminar. Professor Adoracion is a full professor of labor rights in Valencia. She has a PhD in law from the University of Paris, Nanterre in Valencia, and today she is associate professor in Nanterre, Paris, and she's also an associate researcher of OMA. And this is really, we're really proud of that, of the Human Rights Institute, Joaquin, and also the Free University. She's also a professor in other universities in Europe and Latin America. She coordinates the working group of Lexco, Lex Mercatoria, Human Rights, and Democracy. So, over to Professor Waman. Thank you very much, Manuela. First of all, I'd like to thank you all for the invitation to be here with you this morning. I'm really honored. I'd like to congratulate Manuela and Oma and all the people on organizing this Congress once more, where we have all the approaches and all the discussions from science, from activism, and of about this problem, which is the relation between human rights and businesses and transnational business. As Gonzalo said, that help us be working towards a binding treaty. So it's an honor to be sharing this discussion with colleagues that work with us in the UN, and I always learn from them. Our research would not be the same if we didn't have the opportunity, not only from DINA, from other organizations, to participate and learn every year in many struggles. I think something that's really common to our working group at Glaxo and OMA is that all people are personally involved in the social transformation that we want with our research. In our research, I'm going to focus on this in my presentation is now very focused on a concept that I have to develop, which is lex mercatoria. So in the next minutes, I'm gonna try and explain what this is, to analyze and attempt to define its instruments, objects, and consequences to humans. So we're gonna build on this to explain the pillars used by the transnational companies in terms of laws and standards, to then talk about what are the tools we have today that would allow us to hold this back. So we're going to talk about the problem and talk about the tools that we have to fight this problem, because we're going to have discussion with many experts about it. So I'm going to talk a little bit about what has already been said by Gonzalo, actually. I think it's important for us to highlight that this concept occupies an increasingly important place in today's legal debate. It is what we call the new code of global capital, is justified by its renewed expensive character, which is both quantitative and qualitative increase in trade and investment treaties, and to increase the activity of international financial institutions. Not only the standards, the trade standards, but also the standards that come out of the international financial institutions have a conflictive relationship of both phenomena with mechanisms for guaranteeing human rights, which is combined with the impunity that covers the transnational companies whenever they have human rights violations. So we're going to look into this through the lenses of lex mercatoria, which is complex for you to define. There are many definitions for this. So we're going to try and shed some light to the different approaches. Let's go to the origin, which is 1964 with Goldman. The approach was understand that a set of general principles and customary rules is spontaneously elaborated that appear in commercial relationship without reference to a specific national legal system and based on the paradigm of voluntariness. So basically, the lex mercatora, we have the customs, the contractual clauses, and also the arbitration decisions. So this author would say this doesn't have the legitimacy of democracy coming from a legal system, but it has the de facto fulfills the function of a legal order. So most of the approaches for lex mercatora has focused on autonomy, the capacity of self-regulation of the companies, internationally speaking. We talk about lex mercatoria as international right that's not bound to states, but to the business practices. So most of the authors say this, is the lex mercatoria is a set of standards and laws created by the interests and the companies that will be using it to defend their own interests. And it's not only about it. It's not only about the private sector, between the private sector and also the state, in the public sector and within the state. This specific character of lex mercatore combines with mature autonomies that makes it all almighty. So the businesses regulate their businesses, they regulate how they're going to solve their disputes, and they regulate how the state will behave whenever there is a dispute. So the justification is always the same. The state doesn't work well, there's no capacity for regulating the complexity of the international trade. We have to overcome the state standards or frameworks, because we wouldn't have those would apply to the commercial relations. So we have to overcome this slowness of the state, so that we can improve trade and will improve the economic activity. The autopoietic character also leads us to put in the center of the legislatory subjects, which are the transnational business. I'm going to be talking about the concept of transnational businesses. And so these international companies, according to this perspective, will replace the legal sources that we use usually. So it's parallel to international law to regulate companies that have actually replaced the international law. So they understand as a global unit what for us is the international society. The many authors, especially Bucciarati, which is a Spanish author who has taught us a lot about it. Juan Hernandez would talk about Lisa, would talk about the expensive character of Alex Mercator, and he would agree with the idea of having a diffuse sovereign standard that's not only with the transnational companies, but also the financial institutions, international financial institutions. So we have to think of Lex Mercator not as something created for the companies, but created by the companies for themselves. And this breaks with the character of a monopoly in creating state standards. This is really important. It's just like other authors say, this is the moment where we break with the classical right, when we have regulatory jungle where states will lose their monopoly, and then we have heteronomy to another thing. And other authors recognize the lack of legitimacy of regulatory law. So it's the absence of a democratic base that would justify the standard production. So this would be the problem. But first, to understand the concept, especially if you think of human rights, which is what we focus on with Manuel and all the team, I think it is important for us to have our own definition and challenge some of the characteristics. Because what I said is a patchwork, a set of definitions that have been created from the business science, especially trade science, to try and define and justify the existence of a Lex Mercatoria. An independent set, a de facto standard, but that should also be respected by the state. And this has to be reinterpreted. And we need to have our own definition that is linked, as Fernanda said, understand the Lex Mercator as the new global order, a global order that reinterprets and formalizes the legal framework at all levels. A global order that's a tool to protect the interests of the transnational capital, also called international investment, but has an impact on the politics of the states. Our approach doesn't it's not a focus on autopoietic character. We need actually the institutional power to dominate. So there are many techniques for you to do these. One is the corporate capture. So it's not only independent. What we do have is the production from the business that would demand some kind of legal framework, but it's the states, especially the financial institutions globally, that will take on this responsibility and will create a legal framework through treaties and agreements, and also through the agreements between the IMF and the states that actually change the behaviors of the states in favor of companies. This concept has been developed by many authors. We use this in our campaign first for them to have this control by the companies. It's important for us to have this corporate capture. And this today we have to talk about the idea that well we this doesn't have to be captured because the president himself is a banker. I'm not going to be talking about this, but I think it's important for us to be reminded that this is linked to Lex Mercatoria. So far, we have a set of rules whose subjects are the transnational companies, that are those who demand behaviors and legal frameworks and mechanism for solving disputes that are imposed on the states, and they normatize through investment trade, which is the first pillar of Lex Mercatoria, and through the financial, they work through the international financial institutions, the second pillar. And this allows for more dominance of transnational companies that are branched out in chains. And this also is an impunity legal framework so that the transnational companies will violate human rights and they are not held accountable because Lex Mercator, what creates, it's a normative asymmetry that through which Lex Mercator is really powerful, that creates rights for the companies. Meanwhile, human rights is not as strong and cannot establish international legal framework or binding ones that would oblige the businesses to respect human rights. This is the normative asymmetry that many authors have talked about. And also the problem that if we think of communications, high-level communications, if you think of UN and Human Rights Council, what we see is that more and more there are communications of human rights violations by these companies because instead of stopping violations, the expecatora actually allowed it to happen. So we have four things for us to look into. We, we, we know them, so I'll go quickly. The concept of transnational companies and the problem that they create today. The two frameworks with the investment of trade and investment, and also in investments, which is and which I would say it's critical, but also our binding treaty. But I'm going to highlight some things. First of all, the difficulty of this concept, this has to do with what we have found and discussed in our campaign when we try to conceive and use legally the concept of a transnational company, because the name doesn't have a single definition. The international text they use multinational companies, others say transnational companies, but we don't have a single definition. So I wouldn't use this name, and I would focus on the activity. So I think it is really useful for us to have this concept, and it's important also for us to understand that the transnational companies have the decentralization, the localization, and these things are for their own activities. This is important because I have to see the responsibility. Going to be talking about later, but we have to be clear about that. Where this decentralized is not an activity of everybody. It's their own activities that the state legal framework will create a solidarity responsibility between the headquarters and the branches. The other concept for these transnational companies that's important when we make negotiations for the treaty, which is really crucial for creating the diligence, is the value chain. or the supply chain. There are many definitions that to understand the mechanism how they produce it. So when they have a value chain, they're not only creating relations of social dumping, regulatory competency, but they're also competition actually, but they're creating also a competition with the state companies. If you think of textile industry in Bangladesh, there are many authors that have talked about it, that the first, second, third level supplies compete so that they can attract the the international investment to a workshop. So this has an impact on the working conditions of people who work in these um, workshops. So in 2019, more than two-thirds of the international trade was created in these chains, and we're not focused on formalized work. We have to focus on the real work of this chain. According to ILO, it's 20% of the international work or labor actually. So it's important. The impact that these companies have is really important for the ILO regulations. But if you're thinking about studying these international companies so that we can come up with the principles for our binding treaty, we have three approaches. One, human rights violations in these international companies is intrinsic to the model. It's not something exceptional. The violations, the risk of violation is inherent to the production model established. In this sense, if you have only small fixes, as we have, it's useful, but the problem is why do they choose these countries where labor standards, human rights standards are vulnerable? They choose because the working model is with the human rights violation. The second starting point is the model itself of delocalization and integrating, I don't know, many legal frameworks is chosen to create this impunity that Manuela talked about. And this allows fighting places where we can violate human rights more easily and where there is impunity because there are many legal entities that overlap. So there are studies that show that even when we can sue them, there is impunity. And the third point, when you think of human rights, is that the state law in these situations is not enough, or it's too much for the state law, the phenomenon. So the localization, what they try to do to avoid all the controls by the state. That's not only about the standards, but about the unions, etc. So we still have human rights legal framework, but they avoid all these laws. This before I end this analysis, I think we want to do something that's very important for the pandemic.
This is extremely important because it makes it clear that we don't have any type of ethical behavior, or at least a manifestation expression of this kind of ethical behavior in the environment of trade. And this, for example, in the textile industry, the headquarters, they suspend the orders, the manufacturing orders, and they leave thousands of workers incomeless. So the study in Bangladesh showed that 150,000 workshops had their orders canceled, billions of dollars, and thousands of workers were left without any kind of income and without any kind of compensation. When they resume manufacturing, they select workers again in order to eliminate unionists. So this kind of behavior is obscure and it's extremely unethical, violating all sorts of human rights. Unfortunately, we cannot go further into the study of different elements of this fact, but we have a number of different behaviors that impact human rights. There is an essential study that was reported by Dr. Schultz to protect and respect human rights from seeing how these obligations are canceled by free trade agreements, specifically the mechanisms of provisioning of services, and also specifically by the mechanisms of controversy resolution between states and investors. In 2015, when we saw that we were witnessing a violation of Article 14 on the International Treaty of Human Rights connected to ESDS, and that showed that it's an obligation. We must make it clear that part of our struggle must be connected to the procedure of defense of ESDS. This became a weapon used by companies to violate human rights. Chevron, for example, is a case that makes it clear that even if you win a cause in the national courts, Lex Mercatoria allows the company to go beyond all determinations of national courts, rendering victims unable to obtain due remediation. So Lex Mercatory and the agreements with the IMF, they paved the way to this transnational businesses landing, as we saw in Bangladesh, the making the last link of the textile industry unable to protect their workers. And this, the IMF had previously demanded investment in that region, but these businesses became absolutely vulnerable. The European Union then take over the principles defended by the IMF. So how can we make companies, transnational companies, unable to use this armor that they created for themselves, that defend them and protect their profits, um, releasing them from the obligation to respond for their human rights violations. So based on the guiding principles, it's very clear that they are not working. As wonderful as their intentions may be, the fact is that when these guiding principles did not lead to all the expected results. So the most important point for us now is the binding treaty was central concept in this process, according to which companies should prevent and mitigate potential impacts on human rights. This is a due diligence. Everybody thinks that this is the right way to go, and it's a concept that gained the agreement and the enthusiasm not only of the United Nations, but The second pillar of the guiding principle is something that has been supported by different parties. This is derived from this generalized enthusiasm, but it's based that the fact that each pain has a different concept, a different party involved, social, civil society, businesses. And United, United United Kingdom 2015 has nothing to do with what was proposed in Germany. And there is overlapping with the laws in Norway, and it's different from the proposal of the European Parliament. So it's becoming a disaster in which we are trying to put something that does not correspond, which is remediation, reparation. And it's important. We can try to make the companies to bind part of their behavior to the enforcement of human rights, but they are not going to get something that is essential, which is the victims to have access to reparation and justice, because due diligence can will never replace reparation processes. And I repeat, due diligence is an obligation of means, a due diligence, if we're going to include it in the future directive on European Union. So it's going to take over, it's going to include some sanctions, but not sanctions against violation of human rights, but not to follow due diligence procedures. That can include, for example, if a first line service provider violates human rights, maybe they're going to provide some sanctions, but this is not going to solve the problem of impunity. It's important to remember, and with that, I close this topic of due diligence, that due diligence today is included in the World Trade Organization principles, that today we have the World Trade Organization more interested in binding due diligence in different supply chains. The European Union has different standards, some defending only self-reporting initiatives, but in the European Union, I think that we find two relevant industries on the union of wood, construction, and minerals. They integrate the process of due diligence, but they do not protect human rights by themselves, but rather loyal competition inside the European Union. And so we must be careful with that. There are several interests engaged in these norms of in the standards of due diligence, specifically when we talk about at the national level. We have the transparency, the supply chain in California, in the United States, in Australia, we have a standard from 2018, but we have the hard principles. We have child labor in the Netherlands that are not in effect now. Germany is not in effect now. The transparency principles in Norway of 2021 that is about to be put into effect. And we have proposals in the Netherlands that would then be overlapped with child labor. All of these standards include a number of different proposals. They're different from this mechanism of due diligence. In the German law, for example, you limit the scope of the mechanism according to first level, second level funding parties, something that the OCDE said that was not possible to do. But most of these laws reorient the accountability. Personally, I don't like this transfer of accountability to monitor the enforcement of human rights from the part of companies and investors is not enough. You can trust that people, consumers, with their behavior will sanction themselves violation of human rights from the company. But this is just one part of the policy, because the obligation to control that belongs to the state and not and is not exclusively in the hand of consumers. It's an excessive task to expect that consumers will be constantly monitoring. Of course, the product may be more expensive, and I don't think that they will, consumers will have this orientation to fight for human rights. So this cannot be the provided sanctions for these cases. We must think of the access to justice for people that consider that human rights were not enforced. And if there is limitation to the access to courts, to justice, the state must take over this responsibility. To conclude, and then leaving the binding treaty to the next speech, which is our proposal here, I think it's important to continue to study and continue to support the processes to build due diligence in the sense of what they are only. The European Parliament, the European Commission admitted that the questions of access to justice is something that we cannot include in due diligence, because and we can, but we cannot leave it aside, substituting them for due diligence mechanisms. So with these premises, and without considering due diligence as a primary or secondary guarantee for human rights, we can think that it's a mechanism that may work to our end, but the pursuit to our goals, which is to end impunity and make sure that victims receive a fair treatment, we must address that by other types of standards. That's what we are fighting for years now, not only in the UN, but also in other scopes. And this is the binding treaty. The debate on the binding treaty will continue in the next talks. So I thank you for your attention. I thank Manuela Gonzalo and Human Teams, which are long-term partners that are always encouraging us to continue in this struggle. Thank you very much. Thank you, Adoracion. I think we have a very interesting background to continue. First, to start our first panel, formed by amazing women, all of them speaking from their out of their experience. So we are going to start in panel number 1, international treaty challenges and perspectives, coordinated by Letícia Paranhos of Amigos da Terra Internacional, a long-term partner. From all of this process, that we are conducting in Oman.